Now, wouldn't you want to know how the political party that you voted for uses their money? Wouldn't it be more reassuring if we knew where this funding came from or what process was followed by our politicians to come to a certain decision? Well, that's what the aim is when there's an effort to bring our political parties under the Right to Information Act. But the centre today, yet again, opposed this move. The petitioners, meanwhile, are asking for greater transparency and accountability for political parties. Now, the petitioners cite two orders of the Central Information Commission that support this move. The Central Information Commission, or the CIC, remember, had on the 3rd of June back in 2013 declared 6 national political parties, namely the Congress, BJP, CPIM, CPI, NCP and the BSP, to be public authorities under Section 2A of the RTI Act. This was done after a 2011 complaint filed by the ADR, or the Association for Democratic Reforms, and Subhash Agrawal. However, the centre contends that the top court's decision should not be based only on these two orders. The centre says it is concerned about the party functioning being impacted and about security risks that come along with it. Solicitor General of India, Tushar Mehta, made the submission before a bench headed by Chief Justice D.Y. Chandrachud, which was hearing 2 PILs, seeking a direction to bring political parties under the transparency law. The Communist Party of India, the CPIM, said the party has no objection to the RTI with regard to ensuring financial transparency, but the CPIM also said that there cannot be requests under the RTI on why a candidate has been selected and details on the internal decision-making process of a party. Now, let's first understand what the RTI Act is all about, the Right to Information Act. It aims to provide the citizens access to information under the control of public authorities in order to promote transparency and accountability. Political parties say they are not public authorities, but Section 29A of the Representation of the People Act of 1951 does register them as public authority. Now, who all come under public authorities? Section 2H of the Right to Information Act defines public authority as any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by the Parliament, by the state legislature, or by notification made by the government. Now, this was what the RTI Act is all about, and we have been, using it, and we're all aware of the Right to Information Act and how it empowers the common citizen. But under this very Act, there are 8 exemptions as well. And what are those? They pertain to threat to national security, breach of privilege, endangering life and property, etc. So 8 basic simple categories have been given under the RTI Act, from which information can be withheld from the one who has filed the RTI from information going into the public domain. Now, let me also tell you what happens if these political parties do come under the Right to Information Act. Except for political strategy, other matters relating to finance and administration will be made available to the public. Electoral bonds and their donors will become more transparent, and not only funding but expenditure made by the political parties, especially during the time of elections, can be made public. And that, of course, has been a matter of quite a concern for quite some time now. And remember, currently in India, there is no ceiling on expenditure incurred by the political parties at the time of elections. So what's the problem with getting our political parties under the Right to Information Act? Let me take this to my panellists tonight who are joining me right now. I'm joined by Pradeep Mahor of the BJP. Mahima Singh of the Congress joins me. Avishkar Singhvi, advocate in the Supreme Court, is joining me, and Jagdeep Chokar, co-founder of Association of Democratic Reforms, or the ADR, is also joining me tonight. First, let me go across to Mr. Jagdeep Chokar, who is from the ADR and who is also one of the petitioners. All right. All right. He will be connecting with us. We'll try and reconnect with him. But all right, let me take this across to Mahima Singh. Mahima Singh, what is the problem if political parties come under the Right to Information Act?
Jai Hind. Shreya, it is the Congress that brought the RTI in 2005 in the interest of fairness, justice, and equity. In fact, we were the ones that purported this law, conceived this law, because we wanted to undo the culture of bureaucratic secrecy encouraged by Colonial Official Secrets Act 1923. Now, when the BJP came in 2014, in fact, they assumed power, promising the people of India that, they will run a more accountable, a more transparent government. But you see, BJP and accountability are two far opposite ends of governance. In fact, I won't be overstating if I said hypocrisy, BJP thy name. BJP is the ambassador of hypocrisy. And I would cite two orders by the Supreme Court from today, which will testify why I say BJP is a hypocrite. Because you see, what Tushar Mehta ji has submitted before the court is well known by all of us. So two orders came from the Supreme Court today. In one order, Justice Sanjay Kishan Kaul said that the center takes extreme stands against non-BJP states. Number one, this is in Nagaland women reservations case. Number two is the CJI remarking that seems like you, remarking to the government, to the central government, seems like you keep appointing committees till you get a favorable decision in pesticides ban case. Now, why did I cite these two orders is because I'm talking about the hypocritical nature of this government, of the BJP, because this is the very government that has preferred opacity over transparency. They diluted the 2005 law in 2019 by taking charge of the tenure and salaries of the information commissioners, and a lot more dilutions were made. It was opposed by us and all the other opposition parties, many other opposition parties on the floor of the parliament. Yet those amendments were made and the law was diluted. And if I remember correctly, one of such dilutions, such amendments was that the RTI plea will die with the petitioner by the order of the new law. So if you see today, Shreya, electoral bonds, more than 50% donations go to the BJP, yet there is no answerability, there is no accountability. Questions have been asked, if I remember, in July 2022, the pendency before the Central Information Commission was more than 26,000. And the information denied to the citizens of this country over the past 9 years was pertaining to demonetization. Why and how was it done? Everything. Whatever you question, they will say this is regarding national
but
security,
it's not just about the BJP. You tell me, does the Congress agree with the fact that all political parties should be under the ambit of the RTI?
I said that we preferred the principles of fairness, equity, and justice, and that is what we say today. Whatever is in the interest of the principles of fairness and equity must be brought about in the form of a law, must be imposed upon all public authorities in this country in a fair and equitable manner. Provisions can be provided therein. Of course, I mean, you can define the ambit of privacy and disclosure, but you cannot just blatantly say that we will not provide information. Because why am I pointing to the BJP, Shreya? Because the SG has submitted before the court today that this will not be interest of the privacy of the parties, because electoral bonds, because information denied on issues pertaining from just allow me 10 seconds more. Information denied pertaining to issues regarding demonetizations, to the PM's degree, to the pricing of the Rafale, to the RBI was pulled up by the Supreme Court in 2015 because their disclosure policy, the in-house disclosure policy, went against the RTI law then in place. So it is the BJP more than anybody else.
All
when
right.
it comes to discussing, we'll all say that, okay, let's define the ambit of the law. But the BJP will blatantly oppose because they want to keep all the information to themselves. They want opacity. They don't want the people of this
fair
country
enough,
to know
Mahima.
the disasters that they are cooking up under the sheets.
Okay. All right. Before I go to the BJP spokesperson, let me first get in Jagdeep Chokar, the co-founder of the Association for Democratic Reforms, ADR, who has been one of the petitioners in the case. Jagdeep Chokar ji, please explain to us what made you, file this petition in the courts, and what have you seen so far when it comes to the transparency and accountability among political parties in this country?
We had gone to the Central Information Commission somewhere around 2010 or 11, asking for information about political parties because political parties have denied giving us the information, claiming they are not under the RTI Act. After hearings over 2 years, in which all political parties participated and opposed our request, in 2013 March, I believe, the Central Information Commission, in a full bench unanimous decision which runs into 61 pages, the Central Information Commission, which is the highest statutory authority in the land for the implementation of the RTI Act, said that 6 national political parties are public authorities under the RTI Act. There were no ifs or buts. 6 national political parties were declared to be public authorities under the RTI Act by the Central Information Commission. And the Central Information Commission also said that these parties should appoint their public information officers and provide the information that has been requested within 6 weeks. When none of the 6 political parties agreed to implement the CIC's order, we went back to the CIC saying that your order is not being honored by the 6 national political parties. After 2 years of hearing, where the Central Information Commission kept sending notices, show cause notices, etc., to all the 6 national political parties, after 2 years, the Central Information Commission said that their decision of 2013 was valid in law, it was constitutionally correct, it has not been challenged by anybody, therefore it is final. But the Central Information Commission did not have the wherewithal to get its own order implemented. And it also said that the petitioners can go to any other forum they like, including the Supreme Court. That is why we filed this petition to the Supreme Court in 2016. Now, the 6 national political parties, hang on just a minute, the 6 national political parties are the Congress, the BJP, the CPI, the CPM, the NCP and the BSP. These were the 6 parties which had been declared by the Election Commission as national political parties at that point in time. Today, this composition has changed somewhat, but the principle that national political parties are public authorities under the law of the land, and they have all 6 blatantly refused to implement the order of the highest statutory authority in the land, is the issue which is before the Supreme Court.
Okay, let me take this to Pradeep Mahar. Pradeep, the centre has said, the Solicitor General in fact said today in the court that, CIC orders cannot be the only basis on which it is decided whether or not political parties should come under the ambit of the RTI. Number one, why does the centre think that when there has been an order given by the CIC, why can't it be honoured? And secondly, there's also the security risk, the security threat that has been, given as one of the reasons as to why the center is against getting political parties under the RTI Act. What security threat does the center feel that a person filing an RTI to understand the process or the decision making or about a certain candidate is filed is a security threat?
Yeah, actually, first I will stick to the security threat part of it. Basically, what happens is this political system is running in such a manner. Like, say, for example, we take an example of those electoral bonds, right? So what happens is all parties are being funded by some or the other sources. Electoral bonds are one of them, right? So in case there is some opposition party, and that opposition party, and I'm talking in favor of Congress today, right? So that opposition party is getting funds from somewhere. It can happen to anybody, any of the parties, right? If they are getting funds from some of the other sources. If those sources are out, there is a probability that the source who is actually funding, they might be hesitant in funding opposition party, because they might feel that tomorrow because ultimately when they are going to go into some kind of a dealing or something, they might not get government support. This is very logical, that this applies to everybody. So there has to be some kind of a confidentiality in the funding process. As far as the transparency is concerned, there is the election commission. All the funds that are collected by the party and all the expenditures, everything goes to the election commission. So giving it to everybody, and there are many other threats as well. Now, what happens is, what will happen? Today, if those parties are getting electoral bonds, right? Opposition parties, right? Say, if there is no confidentiality, what will happen? They might start getting funds, through different means, like say, for example, in cash or irrational or irregular means, right? So there can be that possibility. So it will add to the corruption also, right? So this is one scenario of the financial aspect. Non-financial aspect, every party has some strategic practices, right? They have some kind of a strategy to fight elections, to win elections, and that kind of a confidentiality should be there. So I feel that there should be confidentiality in the financial matters as well as non-financial matters, both. As far as this matter is, right? As far as the matter of, like, say, this that rules are not followed, because ultimately rules will be followed when it is passed by the parliament. So parliament cannot be directed, right? Parliament cannot be directed that you have to pass this rule. So it is already subjudicial. Now the matter is there in the Supreme Court. Let Supreme Court decide. And today, if you remember that Justice Chanchud, what did he say? He said that political parties may have a point. So he wants to understand the point, right? It's not something like that he's just passing the verdict that, it was just a discussion. It was not even noted down.
Okay, let me take this across to Avishkar Singh. Avishkar,
please allow me a brief
interjection. Help us understand this ambit.
Please allow me a brief interjection before we move forward from here.
Wait a minute. I just want 20 seconds.
Okay, quickly, Mahima Singh, make your point, and then I'm going to bring in Avishkar Singh into the discussion.
Yeah. See, I want to say thanks, but no thanks to the BJP spokesperson. We don't need that favor that he just conferred upon us. Because what the hypothesis that he has floated across is far from reality. The reality
is continuously opposing it. Shashi Tharoor is opposed.
I did not interject. I did not intervene like that.
I think you are
Allow
not,
me to make my point, Shreya. No interjection, please.
Okay,
no interjection.
Pradeep ji, you've made your point. Let Mahima make her point as well.
You see 5,270 crores out of a total of 9,208 crores received, till 2022, were donated to the BJP, which is 57%, and we are second in that donation. We received second highest donations, which is just 10% of the total, which is just 964 crores, and the third which is the TMC, has just received 706.7 crores, which is 8% of the total value.
So what is the point in
anticipated
putting this
security
data?
risk
I am not able to understand your
BJP,
point in putting this data.
the RTI Act would have never existed. The RTI Act would have never come into being had we anticipated security risks like the BJP.
Who are funding you?
They came to power in 2014, riding upon the revelations that they made through 2014.
Why
the
then
cases,
Shashi
by the
Tharoor is
way, majority
opposing?
of
Why
which
your party
were
line is
acquitted
opposing?
later on.
You are the only
So the
person
BJP
sitting here on
has
the
much
TV
to
channel and
hide.
advocating it.
Please do not say that, for example, I mean, this is funny. You are saying that, for example, opposition receives 57%, the BJP is receiving. They have much to answer. We are receiving 10%.
I was talking about
Even
the
if we have to
democratic fabric
make
of
it
the
public,
country.
I don't think we have much to hide. It is the BJP
This
that has
kind of a
everything to hide. It is the
confidentiality
BJP
should
that
be
is
maintained. This is what I was
deceiving
saying.
the people
I
of the
think you have
country
some
in the
All right.
problem in
process of it.
understanding. Understand my point. What I'm saying is,
Okay,
that
okay,
democracy
Pradeep and
in order
Mahima,
to
we've
maintain
heard
the
you. You've made your
democratic
points.
fabric of the country.
Hypocrisy
Let
lying.
me get Avishkar Singhvi now into this discussion.
This is what I'm saying.
Okay. All right, Mahima and Pradeep, you've made your point. We've heard you. Let me go across to Avishkar Singhvi now. Avishkar, we've heard the political parties, and interestingly, there is a logjam every day in the parliament. But on something as an issue like this, where political parties need to come under the RTI Act, they might have their blame game going on, but they are probably on the same side when it comes to talking about the Right to Information Act. But help us understand the ambit of this act, Avishkar. What is exempted? What does a public authority really mean when it comes to political parties? Are they considered to be public authorities by law? And how much of information can be withheld from the public in terms of political parties refusing to sort of disclose that information when an RTI is filed?
That's a few questions in one, but I'll try to attempt to answer a few of them. If you look at the object of the Right to Information Act, the principal object behind this was to try to curb corruption in public authorities, like we know. And that includes a series and a particular category of public authorities, which are mentioned in 2H. Now, the idea was so that information would be used as a weapon, so that there is enough sunlight and that acts as a disinfectant. And when you look at the definition of public authority in 2H, it talks of 4 categories. Now, according to me, it does sound to logic that a political party which is discharging a very important public function, and there's a recent judgment of the Honorable Supreme Court of 5 judges, where Justice Ramasubramaniam has written this, of what is a public function. And he's, reiterated all the law of the land, including federal bank judgment, etc. There are several judgments. But they all point towards the fact that what is a public authority under Article 12, what is an instrumentality of a state, and what are the functions that even a private body, while discharging public functions, would have certain different obligations. So when you look at, Representation of People's Act, there are disclosures to be made by political parties. Now, as soon as you register as a political party under 29A, whether you become a public authority or not was not clear, but by way of this finding, the CIC has certainly held that they are political party, they are public authorities. The problem is that this must be read with certain safeguards, and of course, I don't mean that any law must be completely one-sided in its approach. There must be safeguards with regard to security and confidential information. But when it comes to matters of public money, when it comes to matters of land being given to political parties, when it comes to tax benefits, when it comes to matters of which every citizen in this country has a right to know under the Right Representation of People's Act, then I believe that they must be treated ejusdem generis with the categories mentioned in 2H. And the categories mentioned in 2H are the categories which are similar, because if you see the second part of 2H, it mentions and includes any body controlled or substantially financed, and it includes non-government organizations substantially financed. So why should a political party escape the rigors of the Representation of People's Act? Now we look at it from another perspective. once the Representation of People Act is there in force to exclude political parties which are discharging an essential public function in a democracy, would do violence to the provisions of the Right to Information Act, because then you're depriving the citizen of the information which he really needs to know for him to make an informed decision in a democracy where everyone has a right to make an informed decision when he goes to vote. So according to me, one should know, of course, where the money is coming from for every political party today. One political party will be getting more money, one will be getting less money. But for all times to come, when we test the law, and of course, Parliament may amend the law and make it, get a explicit change in the law. But for the time being, the Supreme Court is dwelling upon this issue, and I'm sure that they will be able to, reach some sort of interpretation which would avoid the requirement for an amendment of the Act. And the last part is that there are several other acts which require political parties to make disclosures. Now, if those acts require political parties and their politically elected persons to make disclosures in Parliament when they occupy office, then why should a body as a whole be exempt from the provisions? Is the question, is a legal question which I would ask myself.
Yeah, exactly. And that is a question that probably all citizens would ask. Pradeep ji, what is the problem if you are disclosing information under other circumstances? If you come under the RTI and you talk about the funding and you give out details of, where your expenditure is happening, what's the problem with that?
There is no problem with the expenditure. First of all, I very much agree to Avishkar's point of view. What he has stated, if we just conclude that, it comes out to be that, this rule has to be, there has to be some kind of amendments. This has to be discussed because ultimately the exclusions are not clear yet. What has to be excluded and what has to be included. So there has to be a discussion on it. Concrete rules and regulations have to be set, and then only it should be applied to the parties. In this current condition, it is quite immature and it is not ripe enough to be implied on the parties, and no parties are ready to accept it. That is the reason. As far as the financial part is concerned, ultimately...
So what according to you should be included and what according to you should be excluded from it?
Look, this is not something that has to be decided on the TV screen. It is a point of discussion. There should be experts who should be sitting there and they should be deciding. But as far as my personal point of view is concerned, financial portion could not be completely transparent. The basic reason is that if it is transparent, there will be problems to the donors. They will not be ready to donate, or they will not be ready to, put their money into any of the parties openly. So there are chances that there will be some hidden practices going on. Ultimately, what happened was, earlier there was no such policy wherein these electoral bonds or these kind of things were not there. So ultimately, then also the parties were getting funds. But how? So this is a point. Ultimately, that point in time, Congress was there. So they were having their own practices and they were running the country in their own way. Now the things have changed. BJP has had an agenda that they are going to fight corruption. So in order to fight corruption, there has to be a transparency in collecting the funds. So each and every penny that is collected, that is reported to the Election Commission, complete transparency is there. Now, if you want the name of the people who are donating to certain party, that should not be there. If it is there, ultimately they might have some reservations onto it. This is my point of view.
Okay, Mahima, do you agree with this? Do you agree with the fact that if they're named, they will be hesitant
she is going little haywire because
and
her party,
what according to you, I'll ask you the same question, what according to you? Okay.
It's hypocritical rather.
Okay.
Or maybe it is her own personal point of view.
What, Mahima, according to you, should be included and what should be excluded?
Well, I think it is a matter of policy, Shreya, and it will have to be decided by the experts. But logic dies a million deaths when the BJP talks of curbing corruption. The ones that deny debates on the floor of the parliament, the ones that have brought in opaque electoral bonds, the ones that have lied, 1,000 times to the people of this country and continue to do so. The ones that have been aiding their crony capital friends. When I was naming the informations that have been denied to the citizens of this country, one such information, Shreya, is about the list of willful loan defaulters from the RBI, and the RBI denied it. So if this government was so keen on transparency, accountability, and fighting corruption, why hide the list of willful loan defaulters? And when they talk about electoral bonds, and when we say that 57% of that money that has been donated in this country has gone to the BJP increasingly every year, what keeps the BJP from telling this country, when my leader Rahul Gandhi asks on the floor of the parliament, here we are, and I think any rational mind would conclude, why was he disqualified from the parliament? Because this is the question that he was asking. We know majority of that 57% of the electoral donations have come from those crony capital friends. And this is how the BJP is playing its megalomania on the trusting citizens of this country. So I would say that transparency, accountability, had we anticipated security risks, Shreya, before 2005, the RTI Act would have never seen the light of the day. But the Congress was committed to this country, to its accountability towards the people of this country, unlike the BJP, which has strengthened autocratical, tyrannical laws like sedition ever since it has come to the power. So I would say that policy makers should, or the experts should be the ones to decide eventually when the court decides for this law or against this law. It should be left to experts. What, how should be safeguarded, what should be, how confidentiality should be defined. But I think that the BJP will never agree to it. Other parties might, on a rational discussion, on a logical discussion, come to a consensus. But the BJP would never do so.
Okay. Okay. I'm just glad that at least on my show today, the Congress and the BJP have come together on one thing, and that is to not define what to be included and what to be excluded from the RTI Act. When political parties are there, they can be fighting it out in the parliament, but at least under this issue. No, none of you told me that.
No, I think Shreya.
Everybody's telling me the risks involved, but nobody's telling me what they want included and what they want excluded.
As a student of law and you as a student of journalism, I think we would agree on the fact that the TV shows, and the Supreme Court says that the TV shows should not be used as a platform to define policy.
Absolutely, I agree with it.
We have a right to know, and we conferred upon the people of this country.
I agree with it.
To information in the form
But this
of
is a TV show where exactly we've talked about the nuances of the act and the risks and the threats involved. Okay, quick last word to Avishkar, and I'm going to wrap this discussion up. Quickly, Avishkar, you wanted to say something.
By saying that since right to information is a fundamental right, I think the only exception must be any, national security or any extremely, heightened risk of any danger to the society as a whole. Otherwise, I don't see any other reason for excluding political parties from the ambit of the Right to Information Act. And this regards to all their entire functioning.
All right. With that, I'm going to wrap this discussion up. Pradeep Mahar, Avishkar Singhvi, Jagdish Chokar and Mahima Singh, thank you very much for joining us tonight and sharing your perspective on the political parties coming under the ambit of the Right to Information Act. I'm going to slip into a short break right now. News and updates continue on the other side. Stay tuned.